So thank you for joining us today. We appreciate you joining us in this unusual time and also into your evening. We hope you will find it useful. For anybody who missed it when I first said it earlier, this webinar is being recorded. It's completely free, and you can be reassured that the information that you receive today will all be factually correct, because obviously we're all qualified solicitors, all specialising in this area of law. Unfortunately, our practice is a paid for service. We don't do legal aid, we don't have a contract for it. And that is the reason why we run so many of these free webinars, because we want to ensure parents who even can't afford our services are still getting access to the right legal information. So we make sure that we put on as many of these webinars for free for parents to ensure they know what their legal rights are. So without further ado, I will get started with the webinar. Hopefully the screen share works. And then Nicole, if you want to whip your camera off and let me know if there's anything I need to be aware of, okay? Perfect. Can everybody see the screen share? If one of you can just unmute yourself and let me know that everybody can see the screen share, okay?
Yeah, I can see it fine, Hayley.
Perfect, thanks very much. So today we're going to be talking about preparing for annual reviews. I have to include this precursory message here because obviously every case is different, every child is different, and so it isn't individually tailored to your child, but it is going to be factually and legally, obviously, the correct information. So your legal rights, what we're going to be talking about is what the law says, and obviously how it applies to your case might be slightly different, but that's where you can use the Q&A factor. Good preparation is key to a good annual review. I can't stress this enough. It's really, really important to get your preparation right from the beginning. An EHC plan must be reviewed annually. That's a legal right. So if anyone who is watching this and they have got an EHC plan for their child or young person and they haven't had an annual review within the last year, you can contact your local authority and make sure you have one as soon as possible. It's really important that they're reviewed annually because children's needs are always changing and we need to make sure that they have the right amount of support at any time. The local authority must ensure that a meeting is held, and they can require the head teacher to arrange and hold that meeting if your child attends a school. The reality is, as any schools will know who are joining, the local authority nearly always get the school to arrange the annual review meeting. So it's very often that your school will contact you and arrange the annual review meeting, send all of the invites out, and make sure you have all of the relevant paperwork. 2 weeks notice of the annual review must be given. I think it's important for parents to know this because I'm often contacted by parents who are suddenly sprung on that they have an annual review the next day, and that is not fair and it is not legal. So if suddenly your school said, oh, we have an annual review tomorrow or in 2 days' time, in order to allow you to prepare, you have to have 2 weeks notice. So you can say, no, sorry, I need 2 weeks notice and arrange for it for a later date. So if you're in that position, please don't worry, you have that two-week notice period. Reports must be obtained and also circulated 2 weeks in advance. And this is really important again, because lots of parents contact us saying they haven't even seen the paperwork before an annual review. Again, that's your legal right to see all of the paperwork 2 weeks in advance so that you can either take legal advice or sit down and study it. When you've got a little bit of time and you're not, busy with the children, you can actually sit and go through all of the paperwork. So again, you're entitled to that 2 weeks in advance. These are all of the people that firstly must be invited to the annual review meeting, and they're also the people that provide reports in advance of the annual review. So just having a quick run through them, you've got the child's parents or young person. That's very obvious. You have to be there. You are the person that knows your child better than anybody else in the world. The head teacher. So normally the head teacher, and particularly if you're at a specialist setting, there will also be other professionals attend from the school. You might have a note taker. You'll also have any of the therapy team that's working with your child attend. Local authority caseworker, and I know some of you are probably laughing, thinking, yeah, okay, Hayley. Local authority caseworkers must be invited. They rarely attend. You will often find local authority caseworkers attend annual reviews at crucial transition points. So it's very common for me to see with my clients that local authorities might not attend in year 4 or 5, but then suddenly they appear in year 6 because that child is going up to secondary school. So I think it's quite important to be aware that at those crucial transition periods, going up into secondary school, post 16, post 19, you may get a local authority representative, even if you haven't had one before. Don't let that throw you, but just so you know that that's quite normal. The child or young person's progress towards achieving the outcomes in their EHC plan must be considered at annual review. That seems very obvious, but I see so many EHC plans who have got the same outcomes from 5 years ago, and that's completely unhelpful. It's unhelpful to you as a parent and also to the child. You need to look at the outcomes every single annual review. Have any of them been achieved? If they have, you need to write some new ones. And if they haven't been achieved, what steps need to go into place to try to get to those outcomes? Are they too high? Do you need to lower them slightly? Or do you need to change them entirely and they're not suitable anymore? So look at those outcomes in every annual review. If the child or young person is beyond year 9, there is also a requirement to look in preparation for adulthood and independent living. We had lots of questions in advance about this. You just need to be aware that from year 9, it has to be discussed at the annual review. So anyone who's in that position, please, it is your legal right to be discussing preparation for adulthood and independent living. If the child or young person attends school, the head teacher must prepare the annual review report. So in that, before 2 weeks, in the 2-week period leading up to the annual review, the head teacher will generally send you a report that will contain all of the evidence. So it will normally include a speech and language therapy report, educational psychologist report, the school's report, care report if you're in a specialist or residential setting, etc. Your parental views must be in there. And also, if you have a young person, their views should be included as well. The school does not, however, rewrite or amend the EHC plan. So they prepare a report in advance for everybody to see so that they've got all of the relevant information for the annual review. And then following the annual review, they provide a report of everything that was discussed at the annual review and any recommendations. Your school cannot rewrite your EHC plan, only your local authority or the tribunal can do that. And I know this is sometimes a difficult situation that schools find themselves in, where parents are trying to get some help from schools. And schools are, of my understanding, very, very helpful in an annual review situation, but they can only make recommendations. It's the local authority that has to take into account those recommendations. If your child or young person does not attend the school, they might be at home under EOTAS, etc. It's the local authority that must prepare the written report following the annual review. Again, as I was just stating, it has to be prepared within 2 weeks of the annual review meeting. So you should have all of your paperwork 2 weeks in advance of the annual review meeting, and then you should receive the report within 2 weeks of that annual review meeting. And again, that is an opportunity to read through that report and make sure that anything that's in that report is actually what was discussed at the annual review. And that is then circulated around everybody that attended the annual review. So even if your local authority did not attend your annual review, they will receive a copy of the report. That's why it's even more important that that report is accurate and reflects your child's needs and any amendments that need to be made to the plan, because if they haven't attended the actual review, they are going to be getting a copy of the report and their decisions will be made on that report. So it's really important to make sure we get that report right. The local authority must notify the child's parents or young person within 4 weeks of the annual review meeting. This was one of the most common questions that we got asked in advance today. People were saying, my annual review is X, when am I going to get a decision? The law states that within 4 weeks of an annual review meeting, so you can literally pop in your calendar the date of your annual review and 4 weeks later, the local authority have 3 things to decide. 1, that they're going to leave the EHC plan in its current form. They're not going to do anything with it. They're just going to leave it as it is. 2, they're going to amend the EHC plan. So you may have asked for amendments to be made to the plan. And 3, cease to maintain the EHC plan. Ceasing to maintain an EHC plan generally involves children that are older, so young people, and it tends to be anywhere from post 16, but generally post 19 up, because you can have an EHC plan right up till the age of 25, but often is the case that you will get these cease to maintain attempts be made before then, so you might get them at post 19. If anyone is in the stage where they have an older child who is going through an annual review process, next week at exactly the same time, Nicole is going to be running a webinar just on cease to maintain, what you need to look out for, what you need to avoid, what letters you might receive that are not lawful. So if you're not already signed up to that, Nicole will be doing a webinar purely on cease to maintain next week in common pitfalls. If the local authority proposes to continue or to cease to maintain, you will get a right of appeal. So they've got those three options: leave the plan as it is, change the plan, make amendments, or cease to maintain. If they leave the plan as it is or cease to maintain it, you get an immediate right of appeal to the SEND tribunal. So if you're going to be challenging that decision, if you wanted amendments to be made that weren't made, you can immediately file an appeal with the SEND tribunal. And these are the things that have to be included in that letter. After an annual review, the local authority do have, as I've stressed, those 4 weeks. And I know many parents will be stressing behind the screen right now saying, mine's been so many more than 4 weeks. 4 weeks is a legal right, so you can actually force a decision any point after 4 weeks. That's possible to be done. It's very easy to be done as well. So what the local authority have to do, so you might have asked, for example, I've tried to put some context here, whether or not to grant a 4th year at college. And if the LA say no to the request, obviously you get the right of appeal. But they may not actually say yes to your proposed amendments, but they might actually make some amendments themselves. Whether you've asked for the amendments or they decide to make amendments, they have to confirm this in writing to you, and they must also send you a notice of the proposed amendments and the supporting evidence. This is really key because I see lots of local authorities writing to parents to say, we're going to be amending the plan. And that's about as brief as it is. But they do actually have to provide you with a copy of what those proposed amendments are and the evidence. So you really need to hold them accountable for that, because that also gives them some extra time. They then get an additional 8 weeks to provide the final EHC plan. So it's really important when you're looking to prepare for an annual review, what time frame have you got to work towards? Because if your local authority decide that they're going to amend the plan, they can have that additional 8 weeks to amend the plan, which means from the date of your annual review, you might not get your final EHC plan until 12 weeks. So you have to factor that in. That's why this slide is up here. I just want to make parents aware of 2 key dates in terms of transitions and children with EHC plans. For any child transferring, who is not transferring from secondary school to a post-16 placement, but one of all of these other situations here, so infant to junior, primary to middle, into secondary school is a common one. On the 15th of February, you have to have received, absolutely must, legal duty, received your finalised EHC plan telling you where your child is going to be attending. That date is the 31st of March for any young person who is transferring from secondary school to a post-16 placement. I point this out for post-16 to post-16, as I put on the slide, the deadline is at least 5 months before the transfer. You might think, why do I need to know that right now? Apart from the fact of, have you had your annual review already, because you should have done, these are the dates where they should have really been done for those deadlines to take place. So by the 22nd of November last year, you should have had your annual review, or the 7th of January, which is obviously tomorrow, just to allow if they're going to be making amendments. So if you haven't had an annual review and you are in a phased transfer year, it's really, really important that you get onto your local authority, onto the school, and actually get those annual reviews arranged. The local authority are running out of time, not you in that scenario, because they still have the legal duty regardless of when the annual review is held. However, it's very important, if you're going to be asking for amendments and you want them to be considered, you have those legal deadlines that have to be complied with for children in transition years. So it's very, very important, if you haven't had one yet and you are in a transition year, please do chase up those annual reviews as soon as possible. Schools are going to hate me for saying that. They're all going to be inundated this evening with requests for annual reviews. So once you know your legal rights and what your legal rights are in terms of running up to the annual review, and following the annual review, you've got plenty of legal rights. I think I do really want to stress that to parents. The good thing about this area of law, although local authorities often don't follow it, which is just bizarre, is that parents actually do have a lot of legal rights in terms of looking after their children with SEN. So you need to enforce them as much as possible. It's one of the only areas where it's solely reliant on parents. And I know it is a slog. It is day after day after day that you're fighting, but it is reliant on you using those legal rights to your full advantage. So when you get to the annual review, common pitfalls to avoid, and I see this both from parents' side and schools' side, even though schools are just trying to be helpful when they do it. Schools are often overly positive. And this isn't just of mainstream schools, this is sometimes independent schools as well. And what they might do is, because they have therapy teams integrated, they have integrated curriculum, they might be ASD specific schools, they forget to actually say that in the annual review form. They might say, Johnny is doing fantastically well, he's really progressing, he's made great progress. But they won't actually say that Johnny is seeing a speech and language therapist once a week, and he has an ASD qualified teacher, and he's receiving specialist teaching. So it's really important that if you're going to be saying somebody's made progress, you're setting out exactly how they've made that progress, and you're not just saying they've made progress and not actually explaining it. Pre-plan your annual review. Also, if you're going to be going to a tribunal following the annual review, it's really important because the annual review paperwork is likely to end up in the tribunal bundle. So that's why also it's very important to make sure the annual review paperwork is correct, because what you don't want to do is spend a lot of time on the annual review paperwork and then it's used against you in the tribunal, and because you've changed your position perhaps. So take a lot of time running up to the annual review. Make sure you're very clear about what the purpose of the annual review is, and work with the school, particularly if you've got a good relationship with your school, and make sure that wherever you're stating progress, you're identifying the support that is in place. Because the danger of not doing that is you might say, oh, Johnny's made fantastic progress, and not say how he got there. When the local authority look at that report, from their perspective, Johnny's made progress. He doesn't need any of that therapeutic support anymore, and it can be taken away. So don't get stuck in that position. Make sure wherever there's progress, this is how he's got to that progress, and does that provision need to continue? If it does, then it stays. Practicalities then, we need to think, what do parents need to know? That's why you're here, that's why you're listening to me droning on a Wednesday evening. So these are the three things that I want you to think about when you're preparing for an annual review, when you're coming up for your annual reviews. Firstly, what is the purpose of the annual review? That's very important. Why are you there? And that will change whether your child is 2 or 12 or 22. It will be very different. What can you get from an annual review, and how do you get it? So the first thing that we're going to discuss is, what is the purpose of this annual review? And as I've said, that will change over your child's lifetime. As they go into adulthood, it will change again. You might just be cross-checking at your annual review what is being delivered against the EHC plan. So it might be the case that you have an EHC plan that says a lot of things are going to be delivered. It might say speech and language therapy, it might say occupational therapy, and actually in reality that is not being delivered. So sometimes it is just cross-checking. It might be tightening up the specificity of the EHC plan. Parents now are better informed than ever before. There are so many free pieces of information out there. And if you are new to the process or haven't looked at an EHC plan in detail before, if you go onto our website, www.senlegal.co.uk, we have so many free resources on there. There are newsletters dating back several years, all written by our solicitors on a wide range of topics, but there's lots about what a good EHC plan looks like. There's also blog posts on there, previous webinars, etc. So there's lots of free information. So if you've perhaps done your research, you've had a look around and you've noticed that actually when you look at your EHC plan, you've perhaps got some of this woolly wording in there, this as appropriate, as required, initially, benefit from. We call that woolly wording because it doesn't actually give your child much. It's very ambiguous. What the local authority determines is benefit from is very different what you think is benefit from as a parent. And I always try to use the analogy to say, I would benefit from a hot meal. I would benefit from a hot meal every single day. I would also benefit, particularly in the current climate, to a foreign holiday. But I'm not going to benefit from that every day. So if you see this ambiguous wording, and an annual review is a good opportunity to tighten that up and make it clear exactly what your child should receive. Secondary post-16-18 transfer changes. So you might be looking for an actual change in the school setting your child attends. Again, beyond year 9, as we've discussed, you have to discuss adulthood and independent living. So you need to be thinking ahead what's going to be coming next for your child or young person. And also making sure your child or young person's EHC plan continues. It's very important for parents that their child gets the right amount of support and the funding that an EHC brings with it. So you need to make sure you're securing that provision at every annual review. If you want the EHC plan to continue, again, the test is whether it is necessary for the plan to be maintained. And I've just put another note in there. This is next week's webinar. We're going to be doing a series of webinars every single Wednesday in January. We're going to be doing webinars all for free, all that parents and schools can attend. So next week is going to be about ceasing to maintain. You might, however, just be looking for additional provision. So you might look at your EHC plan and think, oh God, I listened to Hayley the other day and actually I've got nothing in this EHC plan. It's rubbish. If that's the case, you need to look at some additional provision. And again, the test is it necessary? And necessary is an ambiguous word because you think, well, what is necessary? And that is why it's ambiguous, because every child's needs is different and it has to be looked at on the individual case of your child at that particular time. So the next question people ask me, and particularly parents, is what can I get in my EHC plan? You're often told by many, many people, no, you'll never get that in your EHC plan. And lots of times parents are actually really misinformed about exactly what they can get in their annual review and in their EHC plan. So 21(5) of the Children and Families Act says healthcare provision or social care provision which educates or trains a child or young person is special educational provision. And I point that out because things such as travel training, behaviour management plans, social communication skills, independent living skills, the ability to be able to do the washing up and go and get something out of the fridge and cook it, these can now all count as special educational provision. And it's historically what local authorities would just say that's social care. But now they can actually be written into Section F of your EHC plan, and then it is a legally binding requirement to provide everything in Section F of that plan. What you can ask for at your annual review, therefore, if it's in this kind of area, it has to fall within this definition, but it's a wide definition. So you should fully utilise it, particularly for your young people, if you've got elder children rather than obviously the youngsters. Again, some common examples of what you can ask for in an EHC plan. Placement in a different year group other than that indicated by his or her age. I think now this is particularly pertinent because obviously with everything going on with coronavirus, there are a lot of children who have perhaps missed out on provision, and lots of parents write me on Twitter saying, well, it's not possible. It is possible to put your child into a year group, a year behind, perhaps if they've run behind, they can get some additional support, but you'd need evidence to do so. You would need an educational psychologist to comment that that's actually the right thing to do. So that is a possibility. Class sizes. Many parents that I represent have children that are in busy mainstream classes and need smaller class sizes, so whether that's an independent mainstream school, a special school maintained or non-maintained independent special schools. Lots of parents ask for amendments to class sizes because their children find it too much to cope in the large mainstream classes. Small group sizes, lengths and frequency of sessions. So if you've just got in your EHC plan speech and language therapy as required, the typical famous word, or opportunities for speech and language therapy or benefits from education, speech and language therapy, you can actually get that specified. So if you get your hands on a speech and language therapist report, You can say, for example, Johnny requires 1 hour of speech and language therapy per week delivered by a speech and language therapist. Again, you'd need evidence to say that that's what your child needs at that time. Psychiatric input is capable of being educational provision. I think this is really important, particularly the world that we're living in now. CBT, access to a counsellor, all of these things can be written into Section F, including input from a clinical psychologist. Many independent specialist settings will actually have access to an independent clinical psychologist on their team who is able to be called against for counselling sessions and mental health. So if your child is suffering with mental health, perhaps we need to look at what psychiatric input would be available to them. Programme content, duration, frequency and skills mix. Again, these things that are in the EHC plans, such as social communication groups, but it doesn't say who's going to be delivering them. You don't need the dinner lady to be delivering the social communication programme to your child. You need a speech and language therapist to be doing so. So all of those programmes, when you go away tonight and you have a look at your child's EHC plan, look for the woolly wording, but also look for anywhere where there's programmes, who's delivering them, how frequently are they delivering them, how often. You need to be looking at these questions because the annual review is a really good opportunity to tighten up some of this wording, because anything that is specified in Section F legally has to be delivered. So it's very important you can get that as tight as possible to secure your child's provision going forward. Parents cannot be required to make educational provision. All hail. We know so many times there's lots in EHC plans and parents are expected to be teachers and therapists and everything in between. It is not lawful to require parents to deliver an EHC plan. So if your local authority kindly suggests you could perhaps deliver it yourself, you can tell them that that piece of case law there tells them that that's not actually possible. So how do you get it? You're all saying, this sounds great, Hayley, or hope you are, you haven't switched off. But you're saying, how do we get there? What do we need to do? Do your research before your annual review. For the reasons that I've set out, firstly, you need to establish why you're going to the annual review anyway. What's your key purpose? But then you need to be doing your research. You've got those 2 weeks for the reports to come through. You can look at them properly. But you can also do as much yourself as possible. And some of this can actually be done in advance of the 2 weeks as well. Anyone who is looking at a secondary transfer or post 16, 18 or moving to an independent specialist school or college, you need to be able to dismiss the alternatives that the local authority is going to present to you. So in advance of the annual review, you should visit all potential placements. So if the local authority is suggesting at post 16, your child can go to the local FE college, and you're saying, no, I want a specialist dyslexia college, you need to be able to satisfy at the annual review why any of those other placements the local authority are suggesting is not going to be suitable. So open up some communications with them. Say, where do you think that is going to be suitable? Or perhaps, you know, other children in the area, other settings that they've been sent to. Go around those schools and make inquiries as to whether they could meet your child's needs. So when you get to the annual review and the local authority caseworker suddenly says, well, this school can meet need, you can say, well, actually, no, they can't because of X, Y, and Z, because you've done your research. Check what they're able to offer against your child's needs and what they currently receive, because your child might be in receipt of 1 hour of speech and language therapy a week, and they might not have a speech and language therapist. So look at what you currently receive and whether they could deliver it. Use a table. Sometimes I think it's really helpful for parents to get a table of the questions that they want to ask every single placement the same set of questions, and then you'll be able to have a direct comparator between all of the different placement settings. And a top tip is to arrive early. All the schools watching are probably thinking, no, please don't, because I know it's very rushing around for them. But if you arrive early, you do get that little bit of other time while staff aren't occupied by other parents and other children. So you just perhaps get a little bit of individual time that you might not necessarily get. So you can turn up 10 minutes early, and obviously you get that prime time, and that's really important. What is your evidence? You have to be thinking, okay, if I'm asking for amendments, I'm asking for a change, I'm asking for a change of placement, how do I justify that? And as parents, you will have a lot of evidence yourselves. You perhaps just don't realise that it's actually there yet. So your emails. If you're in a position, which many of my clients have been, where you have a child that's going to a mainstream school, the mainstream school can't meet needs, and little Johnny's being sent out of class every 5 minutes because he can't cope with the noise, the sensory processing is too much, perhaps he's got behaviour difficulties, and he's just not coping in that environment, and he's being sent out of the class, and you're getting emailed continuously. I know what it's like for parents, just getting email after email. You have to come and pick Fred up, you have to come and pick Bob up, please can you come and sit in the class, he's going to be excluded. All of these different things that are used, keep everything in writing. So even if you get a telephone call and you take your child home, later on that evening you could email the class teacher, oh, I had to come, I had to come pick him up today because of X, Y, and Z. So you're documenting the evidence that you need to justify a later change of placement. If you've got a homeschool book or communication book, that's really quite common. Again, you can just photocopy pages. Lots of them will document, lots of them will document changes throughout the day, behaviour, particularly behavioural incidents throughout the day. Again, really helpful if you're looking at a change of placement. So document them all down. The school's records. You can ask for a subject access request of your child's paperwork, anything in relation to your child at any point. Keep a brief home diary. So even if you don't have a communication log going backwards and forwards between you and the school every day, you can still keep a home diary. You can include meltdowns, you can include even things in the home environment, so sleep disturbance. What's the meltdown like at home? Because often I get very frustrated parents who have particularly ASD children who are managing at school. They're managing fine, and because of that, when they get to the end of the school day, they come home and you're seeing an absolutely monumental meltdown when they come in the door, because they've been holding it together all day at school and everyone thinks they're doing absolutely fine, and then you get to the end of the school day and you're getting all of those emotions coming out. If that is your child, please document that, because parents are often misinformed. Because it's not happening at school, there's nothing you can do about it, and that's incorrect. So please gather that evidence. Other evidence to consider. Local authority or NHS reports. These will generally be called for as part of the annual review process. That's one of the people that they have to ask for reports from, but they often lack quantification. Whenever I say this as well, many NHS therapists jump onto my Twitter to tell me that that's not always the case. I'm sure there are some NHS therapists that will write exactly what a child needs, but I'm yet to see it. So when I see it, I will change this slide. And until then, many NHS therapy reports that I see are very fluffy. They've got the opportunities for, would benefit from, etc. wording in them. Okay. The last point on that slide is that if you can afford independent expert reports, I would advise that you do so. However, if you are going to be going to a tribunal, you are going to have to weigh up whether or not you're going to need independent expert reports then, because if you are, I wouldn't advise that you waste money now getting expert reports if you're actually going to need them at the tribunal, because you'd be paying twice. So they can be helpful, but it would be worth getting some tailored advice about whether to get independent expert reports for your annual review or to simply wait until you get to the tribunal. This is a really important slide about your parental views, because as much as you can get evidence from everybody else, you are able to supply parental views as part of the annual review. And it's actually very important that you use those wisely as much as possible, because they're a real key piece of evidence that you can pop in there. Analyse your evidence in preparation for that annual review. So you might want to work out, as I was discussing, counting out the duration and frequency of incidents, particularly if that plays into your favour, going through that homeschool communication book, going through the emails, and if appropriate, have available a table of all of the different placements that you visited and analyse all of those. Because particularly if your local authority case officer is not attending your annual review, when they receive that report, you have a prime opportunity to already tell them, these are all of the schools that I've considered, and these are all of the schools that I consider cannot meet my child's needs. And I think that's actually really important, because often is the case, parents don't do that in their views, and instead focus on progress, for example. And then what actually happens is the local authority will come back and suggest, well, have you looked at these other alternative schools? So try and stop that by already including that advice in your parental views. Be very specific also about what is being provided now and quantify it. So if you're receiving more than is in your EHC plan, obviously your EHC plan should be updated. If you need more, include your evidence and make sure you also put in your parental views exactly what your child needs and how much. Be very specific also about what is required in the future. It's really, really important not to just look at now, but to look at what's going to be going on in the future. What about if it doesn't go to plan? And this is often the case that parents ask me more than anything else. If the local authority does not amend your EHC plan following an annual review, and I hope after this you will be armed with all of the relevant things that you should be doing in advance of and attending your annual review. And like I've said, after the annual review as well, ask to have a read of the annual review report before it goes to the local authority. If they don't amend your annual review, your EHC plan, you have an automatic right of appeal to the SEND tribunal. Similarly, if the local authority tried to cease to maintain your EHC plan, you have a right of appeal to the SEND tribunal, and they have to continue to provide the EHC plan while you appeal. So again, Nicole is going to be talking about this next week, but parents often think that their child, young person, is going to have to leave a specific placement, and that's not actually the case. Their EHC plan continues while you go for a cease to maintain appeal. So very important for parents to note. If the local authority amends your EHC plan following your annual review, but does not give you what you want, as soon as you get that final EHC plan with those amendments in, you can appeal to the SEND tribunal. And I know not every parent wants to go to the tribunal, but often it's a quicker way of getting what you want than the local authority just wheeling things out for months and months and months, and then you losing your placement, for example, because you haven't confirmed the space. So don't also be fooled by unlawful letters. Lots of the time, sorry, I've just noticed a spelling error that should be LA officers. You get sometimes letters such as agreement has been given for Beth to continue her studies for a further year only. That's unlawful. The reason that you have an annual review every single year is because the child's needs or the young person's needs to be reviewed on a yearly basis, and you need to look at what they need going forward. You can't just decide now in a year they're not going to need this, because how do you know that? You're putting the cart before the horse. They can't do that, and that's actually unlawful for them to do that, so they can be challenged as well. And as I started off this webinar by saying, the timeframes following an annual review are legal timeframes and can be forced with a pre-action protocol letter. So if you are past 4 weeks past your annual review and you actually haven't had a decision yet, you can firstly do a courtesy email to the local authority. It's been 4 weeks, I haven't had the decision, could you send it to me? And then if they're still saying, or not responding, perhaps you can at that point get a pre-action protocol letter written. Very, very common for us to do, and we have no difficulty with local authorities then giving a decision across. So rather than waiting for months and months and months on end, even if you are not going to be using a solicitor to run an appeal, it might be worth getting a pre-action protocol letter to get you your right of appeal, even if you're going to be running the appeal yourself, for example. So that is the law and what you should be looking at, and how we should be running through things. I appreciate, sorry, because of my technical difficulties, there was a bit of a break between, but we have got some time for some question answers. So hopefully I don't close this all down by doing so. But Nicole, if you can try and pop your video on, and I'll try and do the same, and perhaps we can answer some of the common questions.
Yeah, no problem. I've tried my best. My fingers are just stumps. I've been typing so quickly, but you've inundated me. I couldn't get through them all, so we've got a lot to get through. So Sorry,
Before we
Hayley.
just go on to the questions, just in case any parents dip out, although they normally always stay for the Q&As, for anybody who missed it at the start, we are running webinars as a firm throughout January, every single Wednesday at 7 p.m. So next week, Nicole is going to be doing one on ceasing to maintain the EHC plan, particularly pertinent for older children, anyone kind of 16 up. Then the following week, James Brown, one of our other solicitors, is going to be doing basically everything: EHC plans, requests for EHC needs assessments, the tribunal, evidence, so all of the kind of encompassing. And then the following week, Richard is going to be doing a webinar, again, another solicitor our practice, for schools on how to recover funding. And it's also very important for parents to draw that to schools' attention, because if your school is saying that they don't have enough funding for your child's EHC plan, that webinar is specifically about schools making sure they're properly funded. So just want to draw that to parents' attention, just in case they missed it earlier. And also say thank you to my team behind the scenes who, like Nicole, James and Richard have been answering furiously. But whenever we do one of these webinars, we are always inundated with so many questions. Once we actually end the live questions, we will still answer as many as we possibly can. And also, I would just say, keep an eye on our social media, our Facebook, our Instagram, our Twitter, because they are the things that tell us what parents want to know, and that's how we put on these free webinars for you. So if you miss an opportunity today, you can always interact with us through our social media, and if there is enough parents wanting it, we will always put on free services to make sure that parents know what their legal rights are. So without further ado, Nicole, you can give your fingers a rest, and we'll try and get through some of the more common questions.
Okay. So begin at the beginning. Actually, there was a couple of people that asked this in terms of common trends. So can an annual review meeting go ahead if the parent, young person or child doesn't attend?
I would no, it's just completely it's about the child or young person, so you can well within your rights just say that the date and time isn't suitable. That's why there has to be that 2-week notification of the annual review, and if it's not suitable for you, then just let the school know at the earliest opportunity and look for a new date. How a local authority expects to run annual review without the person there is bizarre, but no.
Okay. The next question was from Priscilla Wadsworth. I must admit, Priscilla, I actually clicked answer live when I intended to open up a question, the typing box. You said, is this assuming that the head is SENCO? Basically, my answer was going to be no. It's quite common, actually, that the SENCO and the head are two very different roles. Okay, and actually, I saw this question a couple of times as well. This is about emergency reviews that have been called. So in the event of an emergency review, should the parents be receiving all of the reports and have them circulated as per the regulations?
So they still should be receiving all of the reports, but obviously it depends what the situation is, and that's quite a difficult one for me to answer broadly, because emergency annual reviews, they depend in their urgency. Some will be very urgent situations, in which case obviously you're not going to be able to have all of that paperwork. But if there is any opportunity to gather it, it should still be the case. But it will really depend, because while lots of schools call them emergency annual reviews, sometimes they're not actually emergencies. So it's something that I would have to advise on a more specific basis to those tailored cases, I'm afraid. But generally, you should be getting, it's a must duty. They have to provide the paperwork. But with those emergencies, if they are emergencies, then you might not always get all of the paperwork. So it just depends what the individual case is.
Lovely. Sorry, my dog's just come in the room and I'm getting very nervous. So again, that's what happens if the review goes ahead. So we've answered that one. Done. I have my son's first review on Monday. The only paperwork that I have been given is the current EHC plan and an all about me form for my son to fill out. Is that correct? There was other questions as well, Hayley, which related to, are there particular forms that parents should be receiving before a review? Is there a particular format for paperwork, etc.?
Okay, so there's no specific format for paperwork. Lots of local authorities, obviously we act for all different local authorities in England and Wales, and you'll find that each local authority does it slightly differently. Some local authorities will send specific paperwork that they want to be completed by the school, and they will use that specific format. If your child is in an independent school, many of the independent schools have their own specific annual review report form that they send off. So it does change, but you should always have that list that I put up, and when obviously you get the recording as well, that will be on the presentation, the list of who should be providing the information. So the school itself, parents, young people, healthcare professionals, SALT, OT, etc. All of those people must be asked. So I would just check, if you have an annual review coming up and you haven't received reports, check, are these the only reports? Are you expecting any more reports? Because obviously if there are none, then you've got everything that you need. If others are expected and they're just expecting to hand them to you on the day, you're well within your rights to say, I need 2 weeks to consider the reports, we need to move the annual review. So just be very clear about what reports are coming, and if they are going to be coming too close to the actual annual review, simply ask to move the annual review back. You're well within your rights to do that.
I just want to build on that a little bit, just in view of the more specific questions about parents and young persons' views. When we do see local authorities with fixed formats for parents and young persons' views, unsurprisingly, they tend to give you about 5 questions with about that much room to provide your views. What I would say is that's not a statutory form. It's just what they use, and don't be confined by it. If you want to send in chapter and verse, then you're well within your legal right to do so.
Every school will be regretting this webinar when they get all of the tables of every single school parents have considered and why they need to change a provision. But you know, that's why we're here to tell parents what exactly they can do. But like Nicole's saying, use as much, you know, write them a 50-page report if you want to. They probably won't look at it, but yeah, keep it as confined as you can, but make sure it's detailed and it's to the point.
Yeah, and you can also update it after the review if you want to. You can update it once everyone's had their discussion. The next question is from anonymous attendee, so I don't know your name. It was sent at 7:23, and it's more of a statement of your situation. There's not actually a question in there. If you did mean to ask a question, please do submit it again, and we'll be happy to try and help. Sorry that I just can't quite gather what you're asking, unfortunately. I'm looking now at Cheryl Crabb. She said, I have a situation where my 16-year-old son review has taken place. My son and I prepared well and sent our notes to the school and LA officer prior to the meeting, but the school overpraised, as is very often the case. So the draft has been returned. I assume this is a draft EHC plan and does not reflect any of the clear issues. It is woolly, not specific or quantifiable. I have asked for a meeting to amend the plan, have more evidence, and have a member of IASS attending. It seems that RLA tends to use tactics of stretching time limits and bowing down at the 11th. Anything that you want to advise there, Hayley?
So just really in terms of obviously after the annual review, within 2 weeks of the annual review meeting, that's when the report has to go off. So that's why it's really important, particularly in this kind of case, where you want to actually see that report before it goes to the local authority, because I assume what's happened here is parents attended an annual review and actually discussions have been had about amendments, and then the school has perhaps included their own view after that annual review and parent hasn't seen it before it's gone to the local authority. So you can always ask to see that report before it's actually sent, and this is probably a good example of when to do that. But as it sounds like your EHC plan is actually being amended, what you have got is that amended EHC plan with proposed amendments on it, that the local authority then have 8 weeks to finalise the plan. You don't have to ask for a meeting to go over the amendments. You can simply just write what you would like the amendments to be, and then the local authority will essentially decide whether to include them or not. If they include them, fantastic. If they don't, you have your right of appeal to the SEND tribunal. And again, if you're in that position, you're thinking about going to the tribunal, we've got James's webinar in 2 weeks' time to go through how to do that and how to prepare for tribunals as well.
Okay. Next question is from Amanda Hannon, a situation that we see a lot, Hayley. So in brief, they have had their review in January 2020, various delays, college didn't send the paperwork off on time, local authority then sat on it for ages. So that annual review actually hasn't concluded. They did issue a reaction in October and they've now received their draft, but their next annual review is now imminent because it's been 12 months. Do they have to go ahead with that annual review?
I mean, it depends what your situation is, because you can just argue it's still definitely a right of appeal. So if you were just trying to get that finalised EHC plan because you're going to appeal and an annual review won't change anything, I would just say you just ask for the EHC plan to be finalised, you get your right of appeal, and you go to the tribunal. Something that we're also asked that wasn't mentioned there is that if you're going for an active tribunal, some schools bizarrely still seem to try and run an annual review at the same time. There is no need for that, because when you're going for an SEND tribunal, you are going through a child's EHC plan and just establishing what they need in the plan. So in this case, if you're just looking for a final plan before you go to a tribunal, you just get the final EHC plan and say there's no point in the annual review because you're going to tribunal. But if you're actually looking to just make some smaller changes, then obviously you can have the annual review, but I can't see you're going to be in any better position, although it is a legal requirement to have an annual review every single year. So some local authorities will say, no, we still need the annual review. But in that situation, what I would do is after that 4 weeks has passed since the annual review, get a pre-action in right there and then, and don't let them delay for a whole year, because it's something Nicole and I hear time and time again. And then it's really frustrating for parents when we write them a letter and within 14 days they've just given them the decision because it's on solicitor's headed note paper. And we appreciate that's really frustrating, but do that the 4 weeks so you're only 6 weeks down the line rather than a whole year, is what I would say.
Okay, we've now come to the other half of anonymous attendees' questions, so I now know what they were asking. I found you. And basically what that comes down to, Hayley, is they're now many months on since the annual review, 7 months, 4 months since a panel meeting which agreed a change of place, but nothing's happening. They've got no right of appeal. How do they move it forwards?
Again, that's a pre-action. So if you've had an annual review and you haven't actually had a decision, so if they've said that they're going to amend, you haven't had a final, or you just haven't had anything from them, that right of appeal essentially just stays in situ until they actually issue a decision. So again, they haven't issued a decision, that's unlawful. A pre-action letter can be sent, get the decision for you. And again, if it's to do nothing or cease to maintain, it's a straight right of appeal. And if they're going to amend, they have to provide those proposed amendments, and eventually you'll get your right of appeal as well. So pre-action will solve that.
Okie dokie. Louise Johnson, I think that you've asked a question that's been answered and then you're querying the answer. And I can kind of piece it together from your second question. So Louise is asking about amendment notices. And what she said is, so are they allowed to send a vague notice to say they are amending, but provide no evidence to suggest what those amendments are?
No, so what the law requires them to do is they can say that they're amending, but they must also send proposed amendments and the evidence, which is what allows them to then give that extra time. So if you've just received a note to say we're amending, they actually have to include what the amendments are. So what I would do in that situation is the regulation that you need is on the slides already, so you can just bring that up in front of you and you can write back to say, okay, I've noted you're amending, however, you haven't provided me with the amendments. Please send them to me as a matter of urgency and ask for them. They will generally provide them after you ask that as well. It's just for some bizarre reason, I think because of case capacity at local authorities, they just want to get the decision out quickly, not to miss the deadline, and they forget to actually send the plan. So you're well within your rights to ask for the amendments and the evidence as well.
Perfect. Question now from Mary Louise Sears. She's asking about specialist dyslexia teaching. How can we ask for this and ensure that it is put in?
Okay, so again, look at all of your options. It would depend where your child is at the moment, because obviously if they're in a specialist dyslexia school, by the very fact that they're actually in the school and receiving that support, it can go into their plan. If your child is, for example, in a mainstream school and are dyslexic and wants some additional support and needs some additional support, again, it's going to be about getting that independent evidence. So it's going to be getting an educational psychologist to come and assess your child and actually recommend some. Obviously, if it's not needed, they won't recommend it. They can only recommend what they find out from their assessment. But I would be looking for an educational psychologist to provide an assessment, and if they believe that specialist dyslexia teaching is required, and similarly if that's supported by the school as well. They're two really good pieces of evidence to get that written into a plan. Another common misconception for parents is that children with dyslexia can't get EHC plans, and that's completely incorrect. We deal with, like I've said, all different children from very different ages, 0 to 25, from just dyslexia right through to really severe complex needs. So we've seen many different EHC plans, and dyslexia is also one of them.
Perfect. Not strictly a annual review question, but we'll allow it because we love advising parents so much. Laura Dennis has asked, if the plan says the child needs an hour of speech and language therapy, whose job is it to put this into place, the LA or the school?
It's the local authority. Music to schools' ears. What's often going on there is the school are not being provided with adequate funding and they can't put it in place. It's the local authority's legal duty. It's section 42 of the Children and Families Act. James will cover that in his webinar in 2 weeks' time, and Richard will also cover how schools can get proper funding in his following that. But section 42 of the Children and Families Act, and perhaps more pertinent to advise people about this at the moment with the current COVID situation, section 42 says that anything in section F of an EHC plan must be delivered. There's no way around it. There's no, we don't have enough staff, we don't have enough money. It must be delivered. And even with the current situation with children being at home, section 42 is still in place. So even if you're using this opportunity to still send your child into school to get support, they must still be receiving all of their therapy. So yes, speech and language therapy once a week. It is the local authority's responsibility, not the schools. And if the local authority aren't sending a speech and language therapist in once a week, then very easy remedy to that is, again, my favourite word, a pre-action letter. It's an unlawful requirement for a legal duty. So a pre-action letter will sort that straight away.
Next, we've got Fiona Castle's question. My son's annual review is due now and school wants to have it in the next few weeks. However, he is in year 5, so he'll be going into year 6 next year. Will he therefore need an early review for his year 6 in order to meet the February deadline for transitions?
Yeah, so what you would normally have is, if he's in year 5 at the moment, you'll have your normal annual review this year, and then next year he'll obviously go into year 6 in September, and it will be around November time. So around October, November, they'll contact you. They may call it a transition review as well, just because he's in a transition year. And I think sometimes that can throw parents, but transition review, annual review, interchangeable wording. It's when children are in transition years. And yes, it should be early, but you should allow it to be early, because obviously you have to have that 15th of February final EHC plan. So you want the annual review to be early, get all of the evidence in, because if the local authorities say no to what you're asking, you need enough time to go through the tribunal. The reason being, every single child who's in a transition year gets their final EHC plan the 15th of February, and the tribunal takes 12 weeks to get through. Obviously, these children will be leaving schools in July, so it's really important that if you're going to be challenging a decision, you can get it through the tribunal before they break up in July, so that you have certainty about where your child's going to be attending in the September.
Amanda Smith has asked, we have an annual review due at the end of January, but they have a stage 2 complaint going through against social care in respect of social care provision not being delivered. The social care will be attending the review on behalf of social care. Should we delay the annual review, it will be very uncomfortable. I'll cover that if you don't mind, Hayley, just because social care is very much my remit. But in the context of annual reviews, I would say no, Amanda, please don't. I mean, the review should go ahead anyway as per the regulations, and the local authority ultimately has the power to call the review. But please don't feel so uncomfortable that you can't attend a review to discuss your own child's needs and provision because of the social worker. You have every right to ask for somebody to go there to support you, to act as a note taker, you know, just to be there to offer you moral support. But please don't allow anybody from the local authority to prevent you from discussing your child's needs and what provision they require to meet them. That's absolutely your right. Next question. Oh, if annual review was on 24th November for a young person in a residential college, taking Christmas holidays into account, when does the 4 weeks end?
So it's just 4 weeks in regards. Obviously, you want to be a bit courteous to them over the Christmas break if you're feeling particularly generous, but it is just 4 weeks. So you can count 4 weeks, perhaps allow a week or 2 weeks over Christmas if you're not in any urgent rush, but it is just 4 weeks. That's what the legal deadline is.
Okay. So there's quite a lot of long ones now. And you're being very crafty. I can't help but notice we have more questions now than when we began this Q&A. So I'll have no voice as well as no fingers. There we are. Jane Dillon, this is a general question actually, not necessarily annual review one, but one I think will probably ring true for a lot of people. They're at post 16. They haven't been able to visit any potential placements because of COVID. They've had appointments for next week, but given the current announcement, then dubious as to whether they're going to be able to go. Do we have any advice for them?
My only advice, and I'm very vocal on Twitter about this as well, some schools are doing it excellently and some schools just aren't. It depends really what type of setting you're looking at. The independent sector does seem to be a bit further ahead, but I'm sure there are other specialist settings that aren't independent that are doing just as well. Many, because obviously we've been in this situation for quite a while now, have adapted their situations. So I know some independent settings certainly are offering paper-based assessments, which they would never have done before. So I know you won't be able to physically go around, but they are offering to speak to parents on the phone. Head teachers are phoning parents. They're also doing kind of Zoom or Teams sessions. Lots of them are also doing kind of virtual tours around the school. So at least, even though you can't physically attend, you can obviously look around. Some of them are doing tours, but only when obviously there's no children there. So out of hours, they're showing people around with safety measures in place. Others have done little videos on YouTube that children can watch and see what the school's like. So everyone's doing it slightly differently. So all I would say is, rather than just thinking nothing's going ahead, definitely contact the school. And for some of them, it might not be possible to do anything, but for some of them, they might have information that you can read through, or webinars that you can watch, or little videos, or live streams, or meetings. So it's definitely worth contacting the individual school and seeing what they can advise.
Next question is from Michelle West. She has a location problem. So there are no specialist ASD schools within daily commuting distance. So currently their child is in a mainstream secondary in a nurture class, but that is going to be ending at the end of this year. And the general tranche of a question is, should she expect the mainstream school to be able to provide the services of a specialist ASD school?
I mean, a mainstream, you can certainly get a very good package of support in a mainstream setting, but a mainstream can't deliver what a specialist setting, just by the very nature of what a specialist setting is. It's completely geared up to be ASD specific. All of the strategies that they have in place, even what they have on the walls, what acoustics they have in the classroom, it's all very much geared towards autistic children. So you're not going to get the same in a mainstream class, even though you can get a very good package, for example, one-to-one speech and language therapy, occupational therapy, etc., brought into the school. It's definitely not going to be the same. What I would just ask that parent to weigh up is whether a residential placement is an option, because I know for some parents it's not an option, but looking forward to preparing for adulthood and independence, is it the case that this child could go and actually be a weekly boarder at an ASD specific setting and learn independent skills and some life skills? And plenty of young children are going residential, and parents are seeing huge piece of progress for that. So it's individual, as I say again, it's that individual parent, that individual child. But is a residential setting an option? And even if you don't know the answer to that immediately, you might just want to have a look at what other residential settings can offer, because there are some really fantastic residential ASD settings around England that I would seriously consider you have a look at, if residential is even perhaps an option. And just speak to the school and see what they say, get a feel for them. But anyone who doesn't have provision around, you have to look at what the next best thing is for you, whether that's mainstream with a bolt-on package, or whether that's an independent mainstream school for the small class sizes, or looking further afield, but looking at obviously a residential placement because the commute is too long.
Thanks, Hayley. There's another question here, and it's an interesting situation, again, one that we see quite a lot. So it's anonymous attendee, I don't know your name, sorry, but they have evidently quite recently finished a tribunal appeal in which it sounds like they might have been successful. Well done.
Well done.
But they're still waiting the final amended plan after that. But in terms of the previous annual review dates, the annual review is imminent. The school have said it's still going to be going ahead. And They have been advised that the school can update the tribunal EHCP with targets agreed at the coming review. Is this correct?
Oh, bless them. The school can't overrule the tribunal decision, absolutely not. And it's bizarre that they're even trying to call an annual review, because obviously if you've just had a tribunal hearing, you would have had many experts and tribunal panel and yourself and the local authority also deciding what your child needs, and that has now been decided. So I would actually say there's no need for that annual review to go ahead. Nicole and I have conversations like this with schools all of the time. It's just completely unnecessary and it's a waste of everybody's time. The reason why they might be trying to do that is because Section E is technically not within the tribunal's remit. However, there is case law that was actually included in this presentation, but I didn't point it out for this specific purpose. But James will certainly be doing so in his webinar, B&M in Oxfordshire. And what that says is when outcomes need to be amended because their needs are being updated and provision is being updated in Section F, then by the very nature of those things being updated, Section E will also need to be updated. So if you've just updated your outcomes, which you might have done in your tribunal, then you're not going to update them again with the school. That's just nonsense. So I think they just need to be told that. That might be why they're trying to do that, to update the outcomes. But if they are just updating the outcomes to reflect the new support that's coming in with the tribunal decision, then you might just want to update the outcomes. I mean, outcomes are really they're good for tracking progress, but they're not a legal requirement. So if it's going to satisfy them and you're going to save yourself at one fight, you might want to update. It's going to depend on your individual circumstances, but they certainly cannot touch sections B and F of the EHC plan.
Perfect. Another anonymous attendee question. With regards to potential placements, I assume at phase transfer, when should you start the process of looking for a new school? So their child is currently in year 3 and obviously would be moving in year 6.
So that's probably, I was going to say, it's never too early. That's probably a little bit early, but there is no such thing as too early. I think you can certainly do your research in advance. I would normally advise parents 2 years in advance to start looking for a placement, only because particularly if you're looking at the independent sector, there's quite a wait on placements, and they will know children that are intending on going to them the next year. So they might be offering a place for, you know, September now, obviously for September, and they can get full really quickly. So if you're certainly thinking that an independent school is going to be right for your child, 2 years in advance, and don't panic if you're within 2 years and think, oh my God, I've run out of time. It's just, if you're starting to look at websites, then you can obviously look at the Good Schools Guide, you can look at various things, go onto parent groups, speak to other parents who've got children at that school as well, and you've just got a bit more time to do your research. So I don't think you can ever start too early, but perhaps if you've got a child in year 6, you might want to start looking when they're kind of end of year 4, going into year 5. Certainly you want to be exploring all placement options.
Perfect. There's another question from Katrina Sharp, but that sort of covers how can I visit or review schools when I can't get access because of the COVID situation. So we've already covered that, Katrina. I hope that was helpful for you. Asmita Modha, sorry, I'm rubbish with pronunciation. Your question is, my son attends a mainstream school with an ASD base and his SALT provision is incorporated into the funding for the unit for 10 kids. The NHS SALT will divide her time between 10 kids and has told me she has to prioritise children who are non-verbal, and therefore she has changed the wording on the EHCP from 1 hour weekly SALT to be decided termly as needed as modelling package.
So it's not clear about when that SALT has decided that they can amend an EHC plan. I don't know if that was obviously done through a report, an annual review. But as I said earlier on, the only people that can change an EHC plan is the local authority and the SEN tribunal. So perhaps it was amended for an EHC plan annual review. It's not particularly clear. That sounds like some really messy funding. And I would assume what's going on in that case is that the speech and language therapy is not specifically quantified. So this is a really prime example where if it's not specifically quantified, so for example, 1 hour of speech and language therapy to be delivered per week on a direct basis, that's where you might get shared funding with other children because it's ambiguous about exactly how much they should receive. So what I'd like parents to do is when they go away from this webinar, even if you don't have your annual review coming up, but certainly going into James or Nicole's webinars coming up as well, is actually look at what the wording is in your EHC plan. And I know Section A is important to parents because it will set out what your child likes and dislikes, but please try not to get too hung up on that section because it's not legally binding. The real important sections for in terms of provision is Section B, which should set out all of your child's needs, and Section F, which should set out all of the provision. So if you're looking in Section F and you're having this opportunities for termly would benefit from, go through and even just highlight them, and when you're coming up to your annual review, you know exactly what you want to be targeting. You want to get them more specific, more quantified, and perhaps you could get your own speech and language therapist to advise how frequently they would say, and you can take that to the annual review with you. I'll just say as well, Nicole, because obviously we started the Q&A and the questions are just mounting up. So we will finish question and answers at 8:30 because we are also all going to have to dedicate some time to try and get through as many Q&As as possible. And as I've said, if we don't get through to your Q&A today, I'm ever so sorry. We are trying, we've got 4 solicitors behind the scenes trying to get to as many of them as possible. If we don't get to them, we do have the remaining webinar series. So we've got Nicole's next week on the post-16 ceasing to maintain EHC plans. She will also be able to answer a mass of questions at the end. I will also be on that with her, relying on her internet connection, thankfully. So we will be answering those. We also have James's webinar. Nicole and I are likely to be behind the scenes with Richard as well, answering on that webinar because it's looking like lots of parents are interested, and also Richard's with schools funding. So if you don't get your question answered today, that's an opportunity for you. And also our social media. I'm always ranting on social media. You will find me on there many days talking to parents. So if you have any questions, our Twitter, Facebook, Instagram, you can find us on there. Sorry, Nicole, in case we lose any parents, I just want them to know where they can get resources from us. And just be reassured, if you are coming to us at any point for legal advice, again, unfortunately, we don't have a legal aid contract. It's not something that we can do. We can refer you to other firms that do legal aid, but what we can do is offer obviously paid advice. And if you are coming to us, that is all we do. We are specialist solicitors for SEN. We don't do any other area of law, unfortunately. So it's just SEN law that we do. So Nicole, let's get through 5 minutes of final questions.
Okay, quick fire. There's a few of the same along this thread actually, and it's actually about changing the date or should the review be held now in light of the fact that no one's done an update report because of COVID.
So it must be provided within a year. So it just depends how early the annual review has been called, because obviously it is a legal requirement. It's your right, it's to protect parents more than anything else, but it is a legal requirement to hold an annual review once a year. Some schools and local authorities, because of the times we're currently in, are being a bit more flexible with that because they're just thinking common sense. They're going to have to do another one early when they've got up-to-date advices, so it's not really making much sense. If your local authority and your school are actually of that way and thinking actually it doesn't make sense and are willing to move it, certainly do so. If anyone is being adamant and demanding it, it's probably just because that is a legal requirement, and obviously as a parent at any point you could demand that legal right. So they might want it to still go ahead. If it does go ahead and advice are missing because of the current situation, what I would do is be very clear in the annual review report. So for example, an up-to-date speech and language therapy report is required, but it hasn't been sought. And you know, you can put as one of the actions that a speech and language therapy report will be sought as soon as obviously the COVID situation allows. So whatever you would normally have, if you can't have now and the annual review is going ahead, make sure you include in that report, because if you then want to appeal, you can in your appeal set out, actually we pointed out a speech and language therapy report was needed and here's the evidence for it. So it's just thinking that one step ahead all of the time about your personal situation.
Okie dokie, I've got a question here from Natasha Compton. So she is highlighting that it's sort of all well and good going into these reviews. You've got your evidence, you're very clear on the provision that you need. So what happens then if this school stroke local authority push back and say, well, if you ask for that, they'll say they can't meet need, or this isn't normally available in mainstream settings, etc.?
Firstly, I know Natasha well. We engage with each other on social media all of the time. So welcome, Natasha. A prime example of social media there. But what I would say is that seems like scaremongering, and it happens all of the time to parents. So lots of parents are put off ever asking for something because they're being told from somebody that it's not possible. The reason for that is generally because it's attached to funding. So lots and lots of times, this is where you get the whole, oh, if your child isn't presenting in school, if they're only presenting at home, you'll never get an EHC plan for high functioning autistic children, perhaps, or you never get an EHC plan for dyslexia, or you can't ask that, that's not possible. It is possible. We've seen, I mean, I would hate to think how many EHC plans Nicole and I have seen over the time we've worked together. Many, thousands of EHC plans, and we've seen from the most bizarre, outrageous requests to the really simple ones. So if anyone's telling you something's not possible to have, I would just ask for it anyway. How do they know it's not possible? It's probably because it's going to cost them money, why they're saying it's not possible. I wouldn't be put off. It sounds like scaremongering to me. I would certainly obviously have evidence of it. If you've got evidence of somebody saying your child needs X, if a local authority is saying that's not possible, I would say that's incorrect. They probably don't want to provide it, and you should be aware that you're probably going to have to go to a tribunal to get it. But if it's special educational provision and your child needs it, then definitely it will be possible to get it into the plan.
And just adding to that, in terms of the school itself and them saying they can't meet need, that is all well and good, and they may well return the consultation to say they can't meet need. But in the event of virtually all schools, except purely independent schools, they can't refuse to admit. So they might say they can't meet need, but you can still ask for them to be named in Section I. And if they are named in Section I, they are under a duty to admit. They can't refuse to.
Nicole, we'll just do 2 more final questions after this, but just before we do them, just mention, because obviously every parent listening to this will be involved in the SEN arena in some way or shape or form. Just to mention a couple of brilliant people that we also work with, if you're looking for resources that are not necessarily legal resources. Obviously we are solicitors, we deal with all of the legal stuff, everything to do with legal, but we also work with some fantastic groups. So we've got HACS, Hillingdon Autistic Care and Support. If you've got an autistic child or adult, they're a fantastic service. They're primarily based in London, but they actually provide services throughout. So they're really worth contacting to see what they offer. Similarly with Spectrum Charity, which is a Cambridgeshire-based charity, they do lots of work with many children with disabilities, not just autism, so you can also check them out. Special Needs Jungle, obviously a parent group many parents will be familiar with. I'm a legal author on there. I write many free podcasts, blog articles. Nicole does some podcasts on there and webinars with us as well. So please check that out. We've also got the Dyslexia Show. We work very closely with the Dyslexia Show, and also with John Hicks if your children have got dyslexia. So just while we've got many of you on here, if you are looking for, again, many free resources, do check them out for also some support for the actual family, because I think often families get missed out when you're talking about legal resources. They also provide a lot of fun days out and nice things for families. So have a look at all of those if you get an opportunity to do so. 2 more questions, Nicole.
Okay, I've got one here from David McCarthy. I just want to apologise if anyone can hear my daughter brushing her teeth. It's the joys of working at home. I'm so sorry. Anyway, David McCarthy. If my school is funding a top up of £18 an hour to what the LA pay for the ABA tutor, how can I make that legally enforceable against the LA so it can't be taken away if the school decide they can no longer afford it?
Okay, so again, it's about getting the proper specification in Section F. So if you've got an ABA programme in place, a properly funded ABA programme, then it should all be set out in Section F. And I would set it out in terms of hours. And you shouldn't have to worry about who's providing the funding. If it's in Section F of the EHC Plan, it's the local authority's responsibility to provide the funding. And whether the school is topping up or this, that and the other, that's not your concern as a parent. So for me, it's just very much important about getting Section F specified. So, you know, an ABA programme, how many hours are going to be delivered in school, how many hours are going to be delivered in the home environment, when are you looking to phase that out, how many tutors do you have, how many ABA consultant hours do you have, we put ABA programs in place for children quite a lot. They're tricky appeals to run, but provision specified is really important in terms of ABA, particularly if the local authority are funding it. If you do it in terms of hours, then if the hourly rate goes up, you're not left with any shortfall. So I would do it in terms of hours and get it properly specified and quantified in section F. And don't worry about the funding. The funding is a school and local authority issue, and they should all attend Richard's webinar, and he'll tell the schools how to recover the funding. So just shoot them onto Richard's webinar on the last Wednesday of January.
Okie dokie. Last question then, because actually I get this question a lot, not necessarily in this webinar, but we get calls in the office all the time, and that's asking, should an educational psychologist report be done on a yearly basis for an annual review?
Certainly they should be asked. I think we know from common practice, Nicole, it's very rare that it actually happens. They certainly should be, and again, it will depend what's in your EHC plan. It will depend about educational psychologist's input, but I would expect an educational psychologist to do so. We know local authorities don't have enough money or resources, so often that isn't the case. But it should be done, definitely, but often it isn't. You can certainly ask for one, but many parents are left waiting several years. It tends to be requests for EHC needs assessments. Obviously, if you're going through the EHC needs assessment process, an EP is involved at that stage. It might be worth speaking to the school, because if the school have an educational psychologist attached to them, the school might be able to actually get the report in place quicker than going through the local authority if they're linked to one. But also, obviously, you can get an independent educational psychologist report if you desperately need it. It depends what you need it for, because obviously an educational psychologist can recommend one-to-one teaching, LSA support, etc. But I think it definitely should be the case that you should get one once a year. But often I know from speaking to hundreds of parents, that's not the case they're in. And you should just consider, is that one of those necessary pieces of evidence for you? Or is something else a bit more important to get that provision in there? Was that the final question?
That was the 87th question.
Well done, Nicole.
59, with 59 open.
The thing we love about the thing we love about parents in this field is you are more passionate than anybody we've ever come across, and that's why we just love doing the work that we do. We speak to hundreds of parents. It's what we do as a career, and we absolutely love it. So we currently still have, it's still going up, but there's still 60 unanswered questions. So what we will do is we will just pop ourselves onto mute and turn our cameras off. We will respond for the next 10 minutes to as many as possible. And then at 8:45, we will be ending the webinar. We will make sure that the recording is available. And as I said at the beginning, please make sure that you engage with us on social media. We listen to parents all the time. We only put these sessions on because parents are coming to us with common questions, similar problems, and we are determined to make sure parents get support whether they can afford it or not in terms of the legal sphere. So if you do need further advice, follow all of our social media pages. That's where we post all of these free webinars. And just a reminder, obviously Nicole's is next week on Ceasing to Maintain. James's is the week after on tribunal strategies and everything to do with requests right through to what to look for in a plan. So if you all go away tonight and look at your EHC plans, we can all inundate James in 2 weeks' time on his webinar. And then we've got that funding webinar for schools, particularly with Richard on the last Wednesday. We're also going to be releasing, and this is the first time I've actually remembered, a disability discrimination webinar as well. It's not going to be live, it's pre-recorded, but we will be releasing that in January, again free. So lots of free resources also available on our website. We've got all of our newsletters going back several years, all legal advice in there. We've also got expert resources, particularly while children are at home at the moment. They were done in the first lockdown by many expert witnesses that we work with. There's some speech and language ones on there. There's some occupational therapy strategies that you can do at home, how to ride a bike with gross motor skills. Have a look at them, but there's tons of free resources on our website if you need them. So 10 minutes we'll spend trying to get through as many questions as we possibly can, all four of us. Then we'll turn off the webinar. And if you've enjoyed the webinar today, please do reach out to us and tell other parents, because that's why we put them on, to hopefully benefit you all. So I hope you've enjoyed it. Apologies for my terrible Norfolk internet connection. I will get that sorted when I move house. So thank you all for joining us tonight and giving up your time. We really do appreciate it, and we really enjoy engaging with parents. So thank you all for your time, and we'll do our best to get through the remaining 59 questions. Thank you, everybody.
Thanks. Bye.
Bye-bye.